Hi, everyone. Thank you so much for being here. My name is Carrie Holmes. I am the pro bono manager and a supervising attorney in sunny San Diego at San Diego Volunteer Lawyer Program. Previously, I was a staff attorney and the pro bono director at the Harriet Buhai Center for Family Law. Before that, I was in private practice family law in Beverly Hills and Century City. SDVLP, our mission is to provide equal access to the justice system, but we do that in a particular way by serving as a bridge between indigent and other disadvantaged people in San Diego County who need legal assistance, and the volunteer attorneys and others willing to donate their time and resources to assist. My fun fact is that I am a member of an LGBTQ plus women's dragon boat team. We're called Let's Be Honest. It's my second year on the team, and our first big race is May 13th.
Hi, everyone. Thanks so much to Megan and LAC for hosting today. I'm Harriet Fischer, staff attorney at the California Women's Law Center. Happy to be here with all of you and with my esteemed colleagues, Lisa and Carrie. The California Women's Law Center works to create a more just and equitable society by breaking down barriers and advancing the potential of women and girls. We do this through litigation, policy advocacy, and education, focusing on gender equity issues, including economic security, violence against women, women's health, and gender discrimination. As you probably know, domestic violence disproportionately affects women in every area of their lives. So we hope today's presentation provides some helpful tools for you to use in advocating for DV survivors. My fun fact is that I became an attorney quite recently. And the other is that some years ago, after he was first elected president, I discovered that Barack Obama and I had been living in the same building as undergrads in New York City.
Hi, everybody. I'm Lisa Smith Szekely. I am a staff attorney at the Genesee Center. The Genesee Center is a nonviolent or domestic violence nonprofit organization. We provide holistic and culturally sensitive services. Our services include housing and case management, as well as direct legal services, domestic violence education, and more. I am formerly from the Harriet Buhai Center for Family Law as well. And my fun fact, although I don't know that it's really fun, is that I am a very overscheduled mom with a chaotic 2-year-old and 2 terrible cats. I actually spent like half an hour this morning cleaning up vomit that they left all over my floor. Okay, so today's presentation, we are going to go through essentially the domestic violence statute, looking at the 3 primary things that you need to determine in order to move forward with a domestic violence case, which is, first, do the parties involved have a qualifying relationship? Second, was there a qualifying act or acts of abuse? And third, what relief is available to your client? What relief does it make sense for your client to request? We'll also go through the general timeline of a case from filing to concluding your representation. We're not going to touch on what happens post-representation, meaning enforcement or renewals, because I think those are probably a whole separate CLE. We'll also, and in your materials, you should have already received a link to download some materials that include a sample case file that includes some of the pleadings that you may or may not see in your case. And we'll talk a little bit more about what pleadings you'll definitely see, what pleadings you might see, and what pleadings you probably won't see later on in the presentation. And then we'll talk about preparing, for those of you in the training who are attorneys and plan to represent clients in restraining order cases, we'll talk about trial preparation, the actual process of litigation, and then wrapping up your case. We can go to the next slide. Perfect.
All right, so now we're going to talk about sort of an overview of the legislation that, or the statute that controls everything we're going to be talking about today, the Domestic Violence Prevention Act. So the DVPA is located in the Family Code, section 6200 and following. It's not a terribly long code section, and before you begin representing clients, if you haven't, it's worth it to review sort of the whole thing rather than, you know, just picking out pieces as you're researching. It can really help provide a holistic understanding of everything that's possible under the DVPA if you look at it sort of all together. And then one thing we wanted to point out is the purpose of the DVPA, which is Family Code Section 6220, which is to prevent acts of domestic violence, abuse, and sexual abuse, and to provide for a separation of the persons involved in the domestic violence for a period sufficient to enable these persons to seek a resolution of the causes of the violence. And we point that out because that can often be a really useful anchor for opening statements, closing statements, opening and closing sections of trial briefs, sort of remind the court what we're here for. Sometimes that can be the needing a period sufficient to enable the persons to seek a resolution. That can be kind of challenging to think about, I think, as a DV advocate, because to me, the purpose is to give my client at least a little bit of peace of mind, not necessarily to figure out what happened or why the other person engaged in violence. But it's also important to remember that it's always possible for, and we're not going to really talk about renewal, but it's possible for the restraining order to be renewed for lifetime. So there's a kind of implicit recognition in the DVPA that sometimes there can't be a resolution. There's no period of time sufficient to resolve the causes of the violence. Next slide. Okay. So the first step in determining what you're going to do with a restraining order is whether your client has a qualifying relationship. And what a relationship qualifies to get a domestic violence restraining order is in Family Code Section 6211. And so it's a spouse, and each of these includes also former, right? So spouse or former spouse, cohabitant or former cohabitant, currently in a dating relationship or formerly in a dating relationship. The parties have a child in common. And then this is where this slide is a challenge for me because I have to pronounce the word consanguinity, which is really, thank you. Is that right? Okay, good. I practiced with Harriet and Lisa. Any other person related by consanguinity or affinity within the second degree. So that's parent, child, grandparent, grandchild, siblings, as well as affinity, right? That's related in law. So a parent-in-law or a daughter or son-in-law. And this is part one of the irreverent images and gifs that will be included throughout this presentation.
And I just wanted to flag for everybody that if you have a question about whether or not your client has a dating relationship, there is case law available about what defines a dating relationship.
Okay, so there has to be, the second step of your inquiry is going to be, was there a qualifying act of abuse? And there are two code sections that are really key to know and remember and understand here. The first is Family Code Section 6203, which defines abuse as causing or attempting to cause injury, sexual assault, to cause reasonable apprehension of imminent serious bodily injury, or engage in any behavior that's referenced in Family Code Section 6320. And 6320 has been recently updated and includes some additional acts that I think are really important. So behavior that can be enjoined under 6320 includes molesting, attacking, striking, stalking, harassing, disturbing the peace, and coercive control. One thing I really want to point out on this slide is Family Code section 6301 says the length of time since the most recent act of abuse is not by itself determinative. The court must consider the totality of the circumstances. So sometimes a client will come to you and the most severe incident of abuse was quite some time ago. That's not necessarily a bar to getting a restraining order. There are kind of a couple of really seminal cases on non-physical domestic violence that I want to point out to everyone. One which was very recent. So the first one, and I'll put these sites in the chat too, if anyone needs them. The first one is Marriage of Nad Carney, which is where the husband hacked into the wife's email account and attached some of her private emails, including with her family law attorney, to his declaration that he filed in the family law case. And that declaration also said that he had more evidence from the email accounts that could be considered inflammatory and sensitive to certain others. And wife filed a restraining order request saying that he had invaded her privacy, that statement was a threat, and that he had used the information in her email to track her whereabouts. Now, the husband in that case also had a prior history of physical abuse and actually had been convicted of misdemeanor spousal abuse. The trial court didn't grant a restraining order, despite wife's testimony that she was afraid the husband would continue to use information from her emails to continue to harass and control her. But the appellate court reaffirmed and has some really good language in that decision that the abuse does not have to include actual infliction of physical injury or assault, and can include quote unquote nonviolent conduct like disturbing the peace, which means conduct that destroys a party's mental or emotional calm. So if you have a bench officer who you think is a little bit hesitant to grant restraining orders where there is not a significant history of physical abuse, that's a great thing to include in your P's and A's. The next case that I think is really important to remember is Marriage of Evil Sizer and Sweeney, which is a very easy to remember name. And again, it's a similar case where the husband downloaded contents of the wife's phone, including tens of thousands of text messages, and specifically went out of his way to tell the wife's father some private and sensitive information about her. Importantly, the wife testified that she, knowing that he had this information, gave her sleepless nights, made her sick to her stomach, shocked, embarrassed, made her fear for her safety. Trial court granted a restraining order after hearing, and it was upheld on appeal. The most recent case that I want to talk about is McCord v. Smith, which talked about coercive control as the basis for a restraining order. And one of the facts in McCord v. Smith was that the McCord sent Smith a photo of her nursing license and said, "Is this yours?" And she said, "You know, you don't need to have my license, don't do anything with my license." And then he responded to that message with a photo of a sexually compromising photo of her that she had sent him during their relationship. And the court said that that was part of a larger pattern of harassment and abuse that was a threat to her to disclose those private photos and to do something with her nursing license. So coercive control is really about establishing a pattern of behavior, or maybe, just sending a text with a picture of a license and saying, "Is this yours?" might not on its own seem like it's a threat, but within the context of the party's broader relationship, very clearly is one. So when we're talking about coercive control, we want to establish a pattern where there's isolation, sometimes deprivation of basic necessities, controlling, monitoring movements, tracking locations, showing up where at workplaces, that kind of behavior. We also see in coercive control cases quite often threats based on a petitioner's actual or suspected immigration status, and also reproductive coercion. And reproductive coercion is now specifically mentioned in 6320 as an act of abuse. Next slide.
All right, so the next thing that you need to think about, once you have determined that there is a qualifying relationship and a qualifying act or acts of abuse, is what kind of relief will most benefit your client. The DVPA allows for an extremely broad range of relief in theory. That this relief includes the personal conduct orders, which means don't contact this person, the stay away orders, which means don't go near their home, their car, their school, their job, their children's school. There is a prohibition on the possession of firearms. And I know that there's been some news lately about cases in other states and jurisdictions in which the constitutionality of these prohibitions on firearm possessions is being challenged. But as of right now, the law in the state of California is that a family court, as part of a restraining order, can tell an abusive person that they can't have guns. So at least for now, that is the state of things. The court will almost always grant the order for the recording of communications. And this is very helpful because California is a two-party consent state for recordings, which means that contact from the other party can sometimes be difficult to properly introduce in a case. But if you have the order for recording communications, then you get over that hurdle. If the parties share a residence, the abusive party can be ordered to move out of the home. And it is important, if you're going to get that move out order, you do need to specifically state the reason that your client has the legal right to remain in the location. And that could be that she is a tenant and has lived there for years, even if she's not on the lease. So the fact that your client isn't on the lease or isn't on title does not necessarily mean that a move out order cannot be granted. The court can order care of animals. And then the additional orders that the court can make as part of a restraining order case are custody and visitation, child support, property control, meaning this person has exclusive use and possession of the family vehicle, or things like that, or no transferring or booting the survivor off of the insurance policies, spousal support, child support, the repayment of debts, and the right to like a phone line if the parties share a phone line. Now it is something to keep in mind that different judges have different practices in terms of what kind of orders they're willing to make. Many of these orders are may grant, not shall grant, which means that you may have a judge who simply thinks if spousal support is an issue, it should be addressed in a petition for custody and support or in a dissolution case, or legal separation case. And they may decline to make spousal support orders as part of your DVRO. Your client is entitled to ask for them, but it is a may grant rather than a shall grant. And so it may not be heard by the judge that hears the DVRO, which is why it's important to kind of have a familiarity with the practices in the various courtrooms that you'll be appearing in. There is a right to attorney's fees for a prevailing party. I know that a lot of our participants are nonprofit legal services providers. It is possible for attorney's fees to be awarded to a nonprofit agency and actually Carrie's institution, SDVLP, is the source of the case law for that, which is in remarriage of Ward. And in remarriage of Ward is a very great case. If you had a party who was particularly obstructive during the proceedings, required a unusual amount of attorney time to handle, you can seek attorney's fees and you can cite in remarriage of Ward. And that case has a very great discussion of the public policy underlying the idea that the same way that a private practice attorney is entitled to attorney's fees, so too is a nonprofit service provider. And I think next slide. Okay, so I am going to, we have a good number of participants, and I think it's really important to stay engaged in these trainings. I know it's Friday afternoon, so I'm going to give you guys a little poll. So Harriet, can you pull up the first question? All right, so this is just to test your instincts. Don't worry about getting the answer right or wrong. I'm going to launch a poll here. And I'm going to give you guys about a minute to answer it. So, can witnessing the abuse of a pet form the basis for issuing a domestic violence restraining order? Oh, wow, you guys are answering fast. Oh man, we're not even going to need a whole minute. All right, I think we have almost everybody here. So I can see the answers on my end. I don't know if you can see them on your end, but we have the majority of the people answering yes, a few people answering no. There is actually a criminal case, People v. Kovacek, and the site is up there on the slide. And there in Kovacek, there was a family dog who was abused in front of everyone. And part of the ultimate kind of criminal conviction made its way up to the Court of Appeals, and they ruled that actually witnessing the abuse of an animal can constitute domestic violence. All right. We'll end that poll. Oh, I can share the results with you guys. Can everyone see the results? Great job, everybody. Okay. And now we will go to the next poll. So Harriet, can you pull up the next question? What about threatening to file for divorce? I'm going to launch this poll. All right, can threatening to file for divorce form the basis for a domestic violence restraining order? All right, any more answers? All right, pretty good turnout. There we go. I'm gonna end the poll and share the answers. And Harriet, let's see the answer. No, generally no. Threatening to file for divorce by itself is likely not going to be considered abusive. That being said, it's a no with asterisks. Which is, it could be part of a pattern of coercive control, depending on the additional facts that you have. But by itself, standing alone, saying, I am going to divorce you, probably not the basis for a domestic violence restraining order. All right, let's see question 3. And I will launch this poll. here we go. What about threatening to release people's private photos? Now, this is kind of a gimme. Given that Carrie just talked about it. All right, we're going to go ahead and end this poll. So yes, threatening to release someone's private images is the case that Carrie was talking about, Evil Sizer v. Sweeney, which is just the most appropriately named case that I can possibly think of in a DVRO proceeding. And we have one more question, which is, Harriet, can we pull that up? Beautiful. All right. What about withholding children from a visit? The parties have a custody and visitation order. One parent decides that they are not going to send the kids on the visits. Can not sending the kids on the visits form the basis for a DVRO? Ooh, this one's more controversial. All right, give you 1 or 2 more seconds. All right. So the answer to this is another no with an asterisk. Generally speaking, simply violating a custody order is probably not going to form the basis of a DVRO. It is more likely that you will be seeking, ex parte orders for the return of a child or a contempt of court. That being said, there is a recent case, which is Ashby v. Ashby, which talks about abusive litigation and violating court orders. That is talked about in the context of a renewal. But it's likely that the arguments in Ashby v. Ashby can be kind of analogized from the renewal context to the initial protective order context. So a no with an asterisk.
All right. So part of your materials that you received, and I think we put, Megan put a link in the chat as well if you didn't have it, is a sample case file with court forms filled out, the samples that you can use and look at. An additional resource, if you're looking for help with the forms, is actually the Buhai Center manual, which I am not saying because Lisa and I assisted with it when we were both there, but it really is, it does a good job of explaining what to put on forms and where. So in your sample case file, you have a DV-100, which is the request for domestic violence restraining order, and that also includes an attached declaration. And one thing I would say, the DV-100 seems to get updated every year. So if it's January, make sure to check and see if the Judicial Council has released a new version of the DV-100. I'm going to skip over the local form for right now. And the DV-109, which is the notice of hearing, that will also get filed at the same time. DV-110, temporary restraining order, if the requested TRO is granted either partially or in whole. So we have a version included in your materials as well. DV-200 proof of personal service, and DV-120 response to request for domestic violence restraining order, which would be filled out and served and filed, hopefully served, by the proposed restrained party. There are going to be local forms that are different across counties, right? So in your sample case file, we've included the declaration re notice, which is a local LA County form. So like in San Diego, we don't use that form. A lot of the court websites, if you're practicing sort of in different counties, will have a DVRO applicant packet or something else like that that includes all the blank forms that you need. So make sure to double check that you have everything. So this is, if you're practicing in LA, you need that. If you're in San Diego, you need a venue declaration. If you're getting a move out order, there's a special local form for that. And then same with requesting service through the sheriff, there's a local form in San Diego for that as well. So just make sure that you're checking out all the local practices wherever you are.
And I just wanted to say that personally in my practice, I litigate quite a few restraining order cases, including cases with represented opposing parties. And I rarely, if ever, see a DV 120 response. There's no requirement that it be filed. And if they did prepare one, it's perfectly acceptable for them to walk it into the courtroom on the morning of the hearing. So you may never see one of those. All right, so we are going to do a very brief comprehension check if you guys are willing and we're able to download the sample materials. This is going to be a few questions about the materials. And so if anybody can see in the sample materials, put it in the chat. When is the client's hearing? And we'll go ahead and do the answer. Right, so the information about the client's hearing can be found on DV 109. Were the parties involved in our sample case married? You can see what relationship the parties say that they have on the DV 100 item 3, where you check off the relationship boxes. Did the court grant the client permission to record the phone calls, if any, from the other party? Yes, they did. You can see what temporary orders have been made in the DV 110, which is the TRO. And finally, oh no, there's two more. Was there a gun involved in the domestic violence incident? No. So in the sample forms in the DV 100, there are very specific questions about whether or not firearms are used. And if there are allegations of a firearm being used, the court is going to be directed to make specific findings about the about firearms as part of the DVRO. And the final question, what did the other party say about the domestic violence incident? If you ever have a DV 120, they may or may not give some explanation about their side of things. You may never see that form in reality. All right, let's move along.
Okay, so we're going to talk about the steps in a typical DVRO case. So the first step is the client will either on their own or with the help of a restraining order clinic or an attorney prepare their application for a restraining order and file it with the court. The next step, step 2, on the day that the client files, assuming they don't file like right at 4 p.m. or something, the court's going to review the pleadings in chambers and will either issue or deny a TRO, and will set a hearing date approximately 21 days away. And the other party is going to have to be personally served. The client can either arrange for someone they know to personally serve the other party, or will have the sheriff's department do it. There is relatively new, I guess maybe not that new, feels new to me, the availability of alternative service for restraining orders. And that is found in Family Code section 6340A2A. And it requires that the court make a finding that, first of all, the petitioner has made a diligent effort to serve, but has been unable to do so, and that there is some reason to believe that the respondent is evading service. So it's a little bit of a higher standard than the standard for alternative service in like a DISO or a parentage matter, because you have to give the court some reason to think that there's evasion, not just that you can't find the other person. Next one. All right, the other, as Lisa mentioned, the other party might file a response. Doesn't happen a ton, happens sometimes. They're not required to. Next one. Okay, there will be the restraining order hearing, which is set 21 days from the date of filing or so. The other party is legally entitled to one continuance, so they can show up and say, I'm not ready to proceed, I need time to find a lawyer, and they'll get it continued. If you are, this is a little bit beyond our scope, but if you're requesting an evidentiary hearing, something that's going to be longer than a regular RFO calendar, in San Diego, those, especially if it's long cause, are being set out quite far. So somebody told me the other day that they had an evidentiary hearing set in like July of next year. So they're really being set out, if they're long cause, a very, very long time in San Diego. Next one, if the court grants the restraining order after hearing will be served on the other party if they're present. If the other party is not present at the hearing and an RO was granted, that person, the restrained party, has to be personally served in order for the RO to be enforced against them. All right.
All right, so now we're going to talk about preparing for the hearing. The first step in any case is to meet with your client. When you're meeting with a domestic violence survivor, it's very important to remember trauma-informed interviewing techniques. I'm guessing that many people here are already familiar with trauma-informed interviewing. But for those of, I'm going to keep talking while we get the slide back. For those of you who aren't familiar, a couple of very important things to remember are that trauma can affect a person's recall, and particularly the ability to recall things in a chronological order. There are ways to help a client recall information where you can ask them about if they remember a feeling, if they remember what the weather was like when the incident happened. It can help them locate that incident. You can ask them about if they remember how old their children were, because a lot of times people will remember, oh, this happened around Christmas. Oh, this happened when our daughter was graduating from kindergarten. And that's going to be kind of particularly helpful in cases where you're dealing with coercive control, where the survivor may be in a very long-term relationship and they may be recalling, 15 to 20 years of incidents of abuse. As part of their application for a restraining order. It's also important to let your client know that it's okay to take a break, that it's okay to show emotion, to remind them that everything is confidential, to have available water and tissues, things like that. It's also important to engage in expectation management with your client from the outset. If your client has a case that's kind of a 50-50 restraining order, then, letting them know that in advance is probably going to be helpful and letting them know kind of the things that they will be asked to do as part of a DVRO case, like testify and be examined by a judge or an opposing counsel. Because then when it happens to them, they have been able to emotionally prepare for it. And next slide.
All right, so the next step is going to be entering into the case. And the form to do that is Form FL 950, the Notice of Limited Scope Representation. You should also, of course, do a legal service agreement or whatever your office's retainer is called that clearly delineates the scope of your representation. And that should, if you're doing just the restraining order, that should match probably the Notice of Limited Scope, or they should bear some similarity to each other. The only other thing I wanted to point out, the notice of limited scope, on the second page, you have to put in a phone number and address for your client because you're only appearing on this sort of one thing, the restraining order. So make sure that whatever address and phone number you're putting there is one where your client can receive mail, first of all, and one that is safe for the other party to know about. Next slide. Okay. You might discover upon reading a client's file that there's substantial evidence that you're going to need to introduce at the hearing, witnesses you might want to call, that kind of thing. If that is the case, you may need to prepare for your hearing a witness list. There's a Judicial Council Form FL 321 for that, an exhibit list. And note that in some places like San Diego, if you're going to have exhibits, you have to do a notice of lodgement for any exhibits you plan to introduce. So again, if I could get something like tattooed on me, it's check the local rules. And the client might provide some additional information that was not in their original DVRO request, particularly information that only arose after that was done, like a TRO violation. So, you might want to decide that you're going to just elicit testimony from your client about that at the hearing, or you might want to sort of have it in writing. And if so, you can draft a supplemental declaration. In that, if there's something that your client hasn't disclosed, maybe consider including a sentence or two about why this new information wasn't in the prior declaration. The client was in crisis, they, went to the restraining order, they had to get it prepared that day because they were so afraid. They might have thought the information was just too old, like it didn't matter what happened 5 years ago, even though, 5 years ago was a significant incident. Or maybe the client believed the opposing party when they said no one would believe her. So a reason like that can kind of help to explain why that new information is there. It's really, really common for a petitioner not to include every single thing in that initial declaration, often because they are in crisis and having trouble remembering. And then the other thing you might want to do is a request for judicial notice, especially if there's any relevant and new case law, especially if your evidentiary hearing is really far out from when the DV 100 was filed. And in the request for judicial notice, you're going to want to look at Evidence Code Section 451 if you're wanting to include some new case law. And that's, that requires the court to take judicial notice of certain things. You might also want to ask for judicial notice of records from other courts, including criminal convictions. And that's Evidence Code Section 452 and 453. That includes some special considerations about records of conviction. That's discretionary for the court to take judicial notice of, but usually if there's a criminal conviction, I've been fairly successful in having the court take judicial notice of that. For judicial notice, I just want you to note California Rule of Court 5.115 provides that you have to give a copy of whatever material you want judicially noticed to the court and to each party. So you can't just sort of show up on the day and say, Your Honor, there's this new case and I want you to take judicial notice of it. You have to, give everyone a copy and give them time to kind of review it before you can request judicial notice. All right, next slide.
All right, so now we're going to talk about preparing your evidence. For those of you who appear in court regularly, this will be old hat. For those of you who are just starting out, very important, California Family Court, the evidence code of the state of California applies. You should review it prior to your hearing. If you want to enter, and we're going to talk about evidence in a little bit more detail in just a minute, but the basics of preparing your evidence for your hearing is you want to make 4 copies of all exhibits, right? One for yourself to reference, one for the judicial officer, one for the testifying witness, and one for the opposing party or counsel. Your exhibits should be pre-marked. You should know in advance if there are any issues with the admissibility of your exhibits, like if it's absolutely going to be objected to as hearsay, you should know the hearsay exception that you're going to use to get this document in before you start. And if you're using any audio exhibits, you do need to have a transcript. In addition to a transcript, if you're using an audio exhibit that is in a language other than English, you should have that transcript translated, and a translator should sign a declaration under penalty of perjury that it's an accurate translation. And moving along.
All right, so there's nothing more embarrassing than not being able to do something because you didn't comply with a rule. The flip side of that is that there's basically nothing that feels better than keeping out an important piece of evidence or not letting the opposing party or opposing counsel do something they really wanted to do because you knew the rules and they don't. I still think all the time about one time I made an objection and the court turned to my opposing counsel and said, "Do you have a response?" And he said, "I don't know enough about that rule to respond." And I just think about it all. It was such a joy. So sometimes coming from a legal services organization, we get underestimated by the private bar and often sometimes even the self-represented opposing parties. And that's really such an awesome kind of superpower when you come in and you do know the rules and you have reviewed all your evidence and you do have an admission plan for each piece of evidence that you're going to try and get in. That sort of being underestimated is a really excellent thing that we have going for us. Next slide.
All right, so now we are going to get into the actual representation at the hearing. So in the post-pandemic or mid-pandemic world, many courts have really expanded their technology capabilities. And remote hearings are available and accessible to parties in a way that they weren't 5 years ago. That being said, you do still need to check your local rules about remote appearances because there may be requirements that vary based on the jurisdiction that you're in, including providing notice or requesting permission to appear remotely. There's considerations in addition to just the local rules though, and that is what is your client's preference? Some people prefer to go in person. They want to see the other party, confront them. They want to, they're afraid that their technology won't work. Different people have different technologies available to them. You may be working with litigants who don't have access to a computer with a camera, and holding the phone up to your face is may not come across as well as being there in person. It's also important to consider what kind of evidence you plan to bring and how you can show that evidence if you choose to appear remotely. Some courtrooms and counties have the ability to share a screen the way we're doing now. Others don't. You may not be able to play a video or have the court hear an audio if you are appearing remotely. I have seen it where attorneys haven't really thought about this in advance, and they end up holding their phone to their computer speaker to play an audio recording, which can be very difficult for a judicial officer to hear. And then there's also the preference of the judicial officers themselves. There's a couple of judicial officers in LA County who seem to really prefer it when people are there in person. And so you need to think about all of these things before you make a call about whether or not you're going to appear remotely or in person. And next slide.
I really wanted this slide with the Moira Rose gif. So Opening statements, the court might not give you a clear opportunity to make one. If you would like to, you can ask to make a short opening statement. I don't think that openings in DVRO matters need to be incredibly long. They should probably be very brief, especially if you're not in an evidentiary hearing. The judge might say no if you're on a regular RFO calendar. But it can be useful to set the court's expectations in the same way Lisa was talking about setting client expectations. It can be helpful to set the court's expectations about what they will or won't, about what the bench officer will or won't see in the case. And you can use it as an opportunity to sort of present your theory of the case, what evidence you intend to introduce, what your client will testify to, especially if there's no physical domestic violence. We have all this case law, all the statutory support that physical violence is not required. It's still sometimes hard for bench officers to remember and grant restraining orders where there is grounds. You probably, so you may want to do an opening where you sort of explain to the court, sort of set the stage for the pattern that you're going to be eliciting from your client about what the experience was like in the relationship. Next slide.
All right, taking testimony from your client. You can prepare this part of your case completely before your hearing, right? If you prepare to take testimony from your client, then you can avoid any surprises in the hearing. So make sure to review the things that your client is going to testify in advance, so that you don't ask a question that that prompts an answer that does not help or in fact hurts your case. It's important to remind your clients to speak slowly, to answer the specific question asked, to ask for clarification if they're asked a question that they don't understand, rather than answering the question that they think the other party was trying to ask. And it's important to remind clients not to interrupt during someone else's testimony. Personally, I design my testimony based on the evidence that I plan to introduce. So that is the order in which I will take things, kind of beginning with the most compelling evidence. It's very important to elicit testimony from your client, not only about the act itself, but about the impact the act had on them, because the client's fear and the impact of the domestic violence is part of what the judge is supposed to consider when deciding whether or not to grant a restraining order. And personally, in most cases, I conclude my client's testimony by asking, if the court was to deny your request for a restraining order today, what would be your biggest fear going forward? Because that is a good way to make sure, even if you kind of missed the impact of the domestic violence questions earlier in the testimony because you were focused on getting in certain pieces of evidence or getting details about the acts, asking that one simple question at the end really gives your client a chance to speak directly to the judge, and remind the judge about what's at stake for your client. And we can move on. All right, so like I said, I structure my testimony from my client based on the evidence that I have. There's a very neat little acronym that you can use to remember the steps that you need to get your evidence in, which is MEOW. You're going to mark your evidence. You're going to identify for the court record what it is, right? So what I do is I say, here I have what's been pre-marked as petitioner's exhibit 1, identified for the record. It is a text message showing communication between the parties on June 1st, 2022. Then you ask your client or the other party the authenticating questions, which will be discussed on the next slides, to verify that the exhibit is what it has been identified to be. And then at the end, you must remember that you need to say the sentence, "Now I move to offer petitioner's exhibit 1 into evidence," because you can go through the first 3 steps And then if you don't offer it into evidence, it is not formally part of the record. Next slide.
Okay. So we're going to talk about a couple of really common types of evidence and restraining.
And we're going to talk about it so fast because I am aware that we are running out of time.
Okay, so featuring a real text message from one of Lisa's cases. Police reports, you have a double hearsay issue. If there are statements in the police report that you really want to get in, it may be worth subpoenaing the officer to testify about their observations. You might not be able to properly get this in. It's possible, maybe under a business records exception. One thing to remember is you can't just show up and be like, this is a record from a business, so therefore it is a business record. You really need to look at evidence code section 1271. There are like very specific things that you need in order to lay the foundation for the business records exception. So anytime you're thinking this is going to be a hearsay exception, make sure you just very quickly go into the evidence code and read the rule and make sure that you have all of the elements that you need. Photographs of injuries or destroyed property can be very impactful. Lisa has helpfully included on the slide sort of the key question. And then text messages are hearsay, but generally if they're from the other party, they're going to come in under evidence code section 1220 as a party admission. Next slide.
All right, we have already talked a little bit about the recordings. Voicemails, you are actually not dealing with the two-party consent issue because the party who leaves a voicemail knows that they are being recorded. That's how voicemails work. But you do have to have a transcript of the voicemail. You should also think in advance about how you're going to play the voicemail for the court. Personally, I have a wireless speaker and I put it on counsel table next to the microphone and I play through Bluetooth. So I download the file to my phone first and then I play it on Bluetooth. Video recordings can be used. Remember, California is a two-party consent state. So if these recordings are not with the consent of the other party and they had an expectation of privacy where the recording was taking place, then they may not be admissible, or using them can potentially expose your client to criminal liability. But there are, of course, times where video recordings, even without specific consent, will be admissible, including recordings from public places, or recordings from like security cameras that both parties knew were installed. Medical documents may be able to come in. It is another, just like police reports, it's a double hearsay issue. Rather than relying on the documents, you may end up having your client testify about the injuries that they sustained and the treatment they received. Personally, I have not had many instances where medical providers were able to come into court and testify. But if it was kind of truly essential to your case and there was no other way to get the testimony in, you could consider subpoenaing those people. And next slide.
Okay, so cross-examining the opposing party, you have sort of two options of how you handle this. You can call the opposing party as part of your case in chief and cross-examine them under evidence code section 776. Versus the other option is to cross-examine the opposing party after their own testimony in their defense. If you're going to call someone under 776, make sure that there's a reason to do so, right? It's perfectly acceptable to only ask a few questions on cross or not to ask any. If all you're able to do on cross is say, on X date, Y happened, didn't it? And the other person says no, and you do that for 15 minutes, you're not really accomplishing all that much. We want to have only be asking questions, of course, like we all learned in law school, that we know the answer to, and always have a point of asking the question. I have in many cases found it incredibly impactful to just let the opposing party monologue on the stand. It depends on sort of who your opposing party is, but oftentimes they will make your case for you if you just let them go on. So you can certainly object, right? If they're not answering your question, they're insulting your client, but that might be very helpful for your case, because here we are in a very formal setting in a court of law, and the opposing party still can't keep it together. So that can be very, very, very useful. There are, of course, two kinds of objections, right? You can object to the form of the question or object to the content. I tend not to really object on form if the other party is represented. They'll just sort of have an opportunity to rephrase. And of course, the bench officers in restraining order matters also ask questions. You maybe can object to the form of a judge's question.
I wouldn't.
I have not ever done that. I can think of a couple bench officers who I think would have let me get away with it maybe, but I would not usually be my first go-to. Next slide.
All right, this is very brief. And you guys, I know that we're at 12 o'clock. We only have a few, sorry, we're at 1 o'clock. I know what time it is. We only have a few more slides, so we're going to keep going. This training will be recorded and available if you need to jump off because you have scheduled other things this afternoon. But we're going to go ahead and finish the presentation. And if you need to go, we understand. And you can use the links that LAAC will send out to get the remainder of the training if you have to leave right now. Okay. So very briefly, preparing your client for testimony from the other party. This is not something that I was actually trained on. And once I started practicing, I realized that I probably should have been. Because of all the things that I discussed with my client, what I didn't discuss was what she needs to do when the other party is talking. It is very common in cases like this. Everybody's emotions are heightened, and it is extremely difficult for a person to listen to someone say things that they know are not true, right? So prepare your client not to react when the other party lies about what happened, right? Being under penalty of perjury doesn't actually seem to make many people more truthful. So prepare them for the fact that the other party will lie. Don't jump up, don't sigh, don't cross your arms, don't shake your head, don't put your head in your hands, just sit and face the judge. And I give my clients a notepad that I put in between us so that they can write notes to me about their feelings about the other party's testimony, which I may or may not do anything with on cross-examination. But if they are writing notes, then they are not making faces and shouting and interrupting, which is good. It's also important to let your clients know about your strategy for objecting to what the other party says. If you are going to utilize the strategy that Carrie described, which is let the other party monologue, you should tell your client in advance that this may be the most helpful thing that you can do, right? And so your client should not be surprised and upset that you are not kind of objecting like it's an episode of Law and Order. And letting them know in advance helps control the proceedings themselves. And next slide.
All right. Thank you for this gift, Lisa.
I hope you all like It's Always Sunny in Philadelphia. It's a terrible show. I love it a lot.
Just add one thing to what Lisa said. Oh, I still have a couple of things to say about that one, actually. What Lisa said about preparing your client. Sometimes I tell my client, like, listen, if I'm not talking,
Harriet, can you go back a slide?
Oh yeah, thanks. I'll sometimes tell my client, listen, if I'm not talking, things are going really well. Like that can be kind of helpful for expectation settings. Okay, so this is about sort of what we're calling the judicial wildcard element, right? Different judges, different commissioners, bench officers run their courtrooms differently. The bench officer might make the call to allow you to do only some of the things we've talked about today, or expect you to do all of them. I think one of the best things you can do is ask your colleagues about what a bench officer's preferences are, what their experiences were like. I think sometimes as legal services attorneys, we like poo-poo networking, but it genuinely is just like making friends. And then when you have an issue, calling your friend and being like, what do I do? So if you're appearing in San Diego, call me. I might not know, but I bet I know somebody who does know. Same if you're, appearing somewhere else. And I also encourage you not to feel like if you feel like the bench officer is giving you a hard time, that doesn't necessarily mean that you're doing poorly. Some bench officers, if they think based on the papers that you've made a good case, they might be kind of stress testing what they think is likely going to be a granted restraining order, and sort of giving the restrained party a wide amount of latitude to see if they can sort of make their case why the restraining order shouldn't be granted. So, don't necessarily assume just because, you're getting your objections overruled and you're having a harder time that you're doing poorly. That might not be what that means. And again,
I've also heard from judicial officers when they do their kind of trainings and meet the judges, that they will say, if I'm going to grant a restraining order, I might be more likely to let the opposing party go on so that they feel like they have been heard.
Yeah. And conversely, right, with some bench officers, if things are going your way, you might speak like 5 words, like it might just kind of all be handled. And a really funny phrase that I think one of the pro bonos at BU High said, don't wrest defeat from the jaws of victory by talking the judge out of ruling for you. So if it seems like judge is asking the opposing party questions that are, really good for your case, you might want to just kind of let things lie. And that's sort of like an experiential judgment call. So the more you do it, the more you litigate, the more you work on these kinds of cases, the more comfortable you're going to be with making those kinds of calls. Next slide.
One more. All right, so we're just going to talk about some post-hearing issues. It's very important to, once your case is over, don't just walk out of the courtroom and let your client stay and get a copy of the papers. You should stay and get a copy of the order and the minute order if available. There have been plenty of times where the restraining order after hearing or the minute order or both do not match the thing that just happened in the courtroom. And it's important to be, if you are there that day in front of the clerk, you can walk those papers back up and say, hey, this isn't the order that was just made. And you can get it fixed in that moment. But if you leave the courtroom and then you download your documents from the attorney portal a day and a half, 3 days later, and there are issues, then you are potentially having to request a transcript, file an RFO to get the DVRO modified. It can be a real hassle. And a lot of that hassle can be avoided if you are there in the courtroom looking at the papers before you leave that day. And next slide.
Yeah, get a transcript if you have a court reporter, which we haven't had in San Diego for like over a year. Yeah. Okay, so final sort of housekeeping matters after your restraining order hearing. I often, oh, bye, Susie. Set up a meeting with the client for a day or two after, so they have a little bit of time to process what the hearing was like. It doesn't have to be an in-person, meeting. It can be on Zoom or over the phone, but that's a good place to sort of review the orders with the client, especially if custody orders were made as part of the restraining order. That can be really helpful. Make sure that if the opposing party was not present at the hearing and the restraining order was granted, that the client knows the opposing party, restrained party, has to be served and the proof of service has to be filed. One of the things the sheriffs, at least in San Diego, will do is like check CLETs and their internal system to see if service has been accomplished if they're called out for a restraining order violation. If the restraining order was granted, I provide my client with like as many copies as they want, basically. One for the car, one for their purse, one for their workplace, one for the kids' school, one for them to sort of have with them all the time, just copies sort of everywhere so that if they have an incident and the police come, they have a copy of the restraining order to show them. We always talk about with the client a plan for what happens if the restraining order is violated. Making sure to keep copies of text messages or phone calls that are in violation of the restraining order. If something more serious occurs, making sure to call the police. I've also had clients take their restraining order down to their local police or sheriff's station, local to their home, and sort of let them know about what's happened and give them a copy of it. Theoretically, on the hope that if a 911 call is made from that client, there will be a quick response given that they know about the existence of the restraining order. As part of my case closure, I like to provide the client written notice of the possibility of renewal. And again, we're not going to get super into renewal, but the thing that you really need to know is that the request for renewal must absolutely be filed before the current restraining order expires. So if your client calls you like the day after it expired, you're likely out of luck. I had to stop myself from swearing there for a second. You're going to have a problem. I usually advise clients to call back my organization or, talk to an attorney 2 to 3 months before the expiration so that there's time to prepare the renewal. One thing Lisa does that she mentioned in our prep call that I think is super duper brilliant is she includes with her closure letters the DV 700 info form that includes all the information a client would need about filing for a renewal. And renewal is really powerful, right? The court has 3 options at renewal. It can not renew the restraining order, it can renew it for another 5 years, or it can renew it for life. So renewal is really powerful, and I really wouldn't want any clients to miss that opportunity. And also probably failure to advise them of it is likely malpractice. Just from the supervising attorney perspective. Then once everything is completed, you can file your substitution of attorney, which is form MC050. The other thing you can do is file a notice of completion of limited scope, which is the FL955. Sometimes, your client is busy and has too many things to do and they can't be bothered to sign your sub out, right? They got stuff going on. The notice of completion of limited scope, really make sure you check the rules of court. It's California Rule of Court 5.425. You have to file a proposed notice of completion along with a couple of other things, serve that proposed notice of completion along with a couple of other things on your client. Wait 10 days because the client has, the opportunity to object, and then file a final notice of completion of limited scope, which gets you out of the case. Next slide.
All right, so this is the end of our presentation. Thank you for those of you who were able to hang with us. It seems like most of you were. I don't see any questions in the Q&A, but we may be able to, can we kind of unmute people to see if anybody has a question now here at the end that we can answer?
You would have to unmute everyone individually if anyone raises their hand, but you can allot a few minutes and see if any questions pop up.
Yeah, if anybody has any questions, put them in the chat, put them in the Q&A. Thank you for hanging with us. I hope that this was a good presentation for you guys. I hope you enjoyed the gifts. We worked very hard on them. You're welcome. I have my email as well as the Genesee Center hotline up here in the resources. If you are in LA County, like Carrie said, if you're in the county and you are, gift game is essential. It is. That's true. if you're in the county and you have questions about a judicial officer, feel free to reach out. I'd be happy to talk through, provide technical assistance. I love the idea that there's so many people thinking about expanding their services to restraining order cases. An attorney in a restraining order case can make a huge difference.
It looks like you have one question in the Q&A.
We do.
Ooh.
It's from Melody Rivas. Any tips to keeping a DVRO representation clear from a separate divorce case?
I mean, one tip would be if you are only helping your client with the DVRO portion of a case, is that you shouldn't include requests for spousal support, child support, custody or visitation as part of the DVRO request.
Yeah, I mean, oh, sorry, Lisa, I didn't.
No, that's it.
Okay. It's really hard. We've had bench officers be like, okay, you're limited scope for the DV only, but there's this custody RFO and I'm going to set them on the same day at the same time, and the issues are pretty related, so I don't really and it's really challenging because you do need some level of cooperation. I think just being super clear from the get-go with the court and with your client about what your scope is. So on every single piece of paper you file, you're limited scope attorney for petitioner. Every time you make an appearance, I'm Carrie Holmes, San Diego Volunteer Lawyer Program, limited scope appearing for petitioner for the restraining order matters only. Just super clear, like a broken record would be my advice.
And then you have to kind of maintain that boundary once you're in the courtroom. So if the judge starts talking custody, visitation, support, disclosures, you have to say, hey, this isn't me. And then you let your client start representing themselves.
Yeah.
Do you need to sub out? It's not a requirement, but if anything is filed later in the case, you will be the person who is on the hook. So I think it's a best practice. Say the other side 2 weeks later files a, untimely motion for reconsideration or an RFO to modify the DVRO to allow him to do certain things like show up to the kids' sports games. If you want to be on the hook for that, then you can stay in the hearing. But if you don't, then you should probably sub out.
I also think most ethics lawyers are going to tell you they want you to sub out or do a notice of completion so that it's very, very clear that you are done and your scope has been completed.
Are you aware of case law that allows raising prior DV allegations when a prior DV, I'm guessing that's DVRO, was denied and a new request is made with a new allegation?
I mean, I think most DVs, if they are denied without prejudice. So, try and get the minute order, try and get something that will say without prejudice so that you can continue to bring it up as part of a larger pattern of abuse.
Yeah, particularly with a coercive control case, right? Like you might have a DVRO denied because the coercive control hadn't reached a level to which the court felt like you had been able to establish the pattern, but 2 or 3 new incidents in combination with that history could get you there. So I think you just, you argue that it's part of the totality of the circumstances. You argue that the previous allegations, formed the basis of a DVRO that was denied without prejudice, and that the new allegations puts the previous allegations in a different, stronger, more compelling light for the issuance of a DVRO. I don't know of any particular case that says, yes, you can talk about allegations that were in a previously denied DVRO.
We have one more in the Q&A. How likely is it for a DVRO to be denied if the responding party doesn't show up? If it does happen, what are the potential factors for it being denied in this case?
It can happen. One big reason that DVROs are denied is if the service wasn't proper. So I've seen it happen where a proof of service was filed and then the judge will ask some questions to make a determination of why the other party wasn't there. And, it could be that the notice wasn't properly provided. And judges have the discretion to continue it to allow more time for service or tell the client you need to refile and get a new hearing date and serve it properly the first time. And I've seen judges go both ways. It could also be denied just because the client, if a TRO was denied, you still get to go forward with your DVRO hearing. And so it could be, ultimately denied at the restraining order after hearing stage after a denied TRO. And even on a granted TRO, the legal standards for granting a TRO versus a restraining order after hearing are different. And oh, goodness, that's my cat. I told you I had two terrible cats.
I was hoping I'd get to see one.
Yeah, you can't keep them out. But the legal standards are different. And so there are facts that could form the basis for a court saying, listen, we want a TRO in this case until we have a full hearing. But if the testimony from the client is not about domestic violence, right? If the client starts talking and the only thing they talk about is an ongoing custody dispute or a lack of spousal support or something, then the judge would deny it, and it very likely deny it in that case. That you really have to have your client focused in on the domestic violence issues. Anything to add?
No, that was great.
Seeing any other questions?
All right, well, thank you guys for being with us. I think if there's no other questions, that concludes our presentation, and I hope it was helpful. Are we going to send a survey for feedback?
I
I think that's a question for Megan, maybe.
That's a
All right,
question.
this is a me question. Yes, it won't be in this. There's usually a survey whenever someone leaves the webinar, but also I send out we send out all the information in a week. So everyone that attended will just check their email, but otherwise just our disclaimer, and that's it.
All right, well, thank you, everybody, and feel free to send us feedback directly if you would like. I always love to hear what we can improve in our presentation versus what you liked, what you'd like to see more of.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.